Hillary, the Movie, was a documentary created by Citizens United, a nonprofit corporation designed to be a feature-length attack on Hillary Clinton. The movie sparked more than just political controversy during the 2008 election. It also led to a landmark United States Supreme Court case about the regulation of campaign spending by corporations. Section 441B of the Bipartisan Campaign Reform Act of 2002 prohibited corporations from publicly advocating for or against a candidate before an election. The act authorized the Federal Election Commission to enforce this prohibition. Citizens United requested a preliminary injunction against the Federal Election Commission in an attempt to prevent the commission from applying the act to Hillary the Movie. The nonprofit argued that the act was an unconstitutional restriction on political speech by corporations, and it therefore violated the First Amendment to the United States Constitution. The district court denied the injunction, relying on precedent that had previously upheld Section 441B as constitutional. Using the special appellate procedures under the Act, Citizens United skipped the Court of Appeals and petitioned directly to the United States Supreme Court. The issue before the Supreme Court was whether restrictions on independent expenditures by corporations to expressly advocate for or against a political candidate are constitutional under the First Amendment's freedom of speech protections. The court held that corporations have the right to freedom of political speech and that the government may not restrict independent political expenditures based on the speaker's corporate identity. Previously, in Buckley v. Valeo in 1976, the court had indicated that the First Amendment does not allow political speech restrictions based on a speaker's corporate identity. In that case, the court drew a distinction between pocket-to-pocket campaign contributions, which go from a corporation directly to a political candidate, and independent expenditures, which support a particular candidate but don't directly go into the candidate's pocket. The Buckley court held that statutory limits on corporate contributions are generally constitutional, but restrictions on independent expenditures aren't. But the court took a different tack in Austin v. Michigan Chamber of Commerce in 1990. In that case, the court found that corporate wealth corrupts the political process, and that corporations' independent expenditures to advocate for or against a political candidate can be constitutionally restricted. Writing for a 5-4 majority, Justice Kennedy determined that Austin went too far. Millions of corporations, he noted, don't have access to large amounts of wealth to spend on political campaigns. Kennedy further reasoned that political speech, even from a corporation, is indispensable to a well-functioning democracy. Additionally, the court found no evidence that corporate speech promotes corruption of the political process. Even if evidence of corruption existed, the government's interest in preventing corruption doesn't outweigh the corporation's constitutionally protected interest in free speech. The court overruled Austin and held that Section 441B can't constitutionally restrict independent expenditures by corporations to support or oppose a political candidate. The court reversed the district court's ruling on the constitutionality of Section 441B and remanded the case back to the district court. Chief Justice Roberts filed a concurring opinion, arguing that principles of stare decisis didn't justify continued adherence to Austin. Justice Stevens wrote an opinion dissenting in part and concurring in part, stating that there is a serious need to limit corporate political speech. Stevens argued that the majority took a radical departure from established First Amendment law. According to Stevens, the framers were suspicious of corporations and intentionally gave corporations less political speech protections than individuals. The framers considered unlimited corporate speech and large pools of corporate wealth to be a lethal combination that would corrupt the democratic process. Justice Scalia wrote a concurring opinion criticizing Stevens's dissent. Scalia argued that the framers didn't resent corporations as they exist today. The framers merely resented the state-granted monopoly privileges that many corporations enjoyed in the founding era. Because these monopoly privileges no longer exist, Scalia argued that the framers wouldn't strip today's corporations of the right to free speech. Lastly, Justice Thomas filed an opinion concurring in part and dissenting in part. Thomas agreed with the majority, but would have gone further. He would have struck down the Act's disclosure, disclaimer, and reporting requirements as well. Citizens United versus the Federal Election Commission was a landmark case that paved the way for giving corporations the same freedoms of political speech that individuals enjoy. The case caused substantial controversy. With front row seats at President Obama's 2010 State of the Union address, the 9 justices listened as President Obama criticized the court's ruling for reversing a century of law and allowing elections to be bankrolled by the wealthiest corporations.